Robbery charges. How can you defend them? Is it possible to get your life back after being accused? I'm Jeff Hampton with the Fulgham Law Firm. Thanks for joining us today on our YouTube channel. Today I want to jump right in to describing for you what the robbery laws are in the state of Texas. And if you wait around to the end of this video, I'm going to give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Now, here's what we're going to do. I want to first break this down by saying when you examine robbery, you need to first ask this: is it a robbery or an aggravated robbery? Two different types of crimes with two different levels of punishment. But before we get to aggravated robbery, let's break down what robbery law is. What does the law say robbery is in the state of Texas? So, according to Texas statutes, under the Texas Penal Code, robbery is when, while committing a theft, that's key, during the commission of a theft, someone, number one, intentionally, knowingly, or recklessly causes bodily injury to another, or number two, intentionally or knowingly threatens or places another in fear of imminent serious bodily injury or death. So that's robbery, okay? Now, let's say, so it can be someone coming up, punching somebody right in the face and stealing their stuff. It can also be somebody coming up and saying, hey, if you don't, well, not even, you don't even have to have a weapon. If you don't give me what you have, I'm going to kill you, right? It can be a threat. It can be that sort of situation. Now, how does it become aggravated? Well, under Texas law, robbery is defined as aggravated if the act of robbery causes another person serious bodily injury. So if you actually make it to where an individual has a serious bodily injury, which is defined as the permanent loss of use of a bodily member or organ, like if they're permanent, if they're crippled, if they're somehow deformed, or they're not able to function the way that they used to function in the past, all of that would line up as an aggravated charge, okay? But then the act of robbery can also be aggravated if it involves the use or exhibition of a deadly weapon, okay? So if a deadly weapon is involved, you could be talking about an aggravated robbery. And then the act of robbery causes bodily injury to someone or makes someone afraid of imminent serious bodily injury or death, and they're 65 years of age or older, or if they're disabled or mentally handicapped, okay? That's what the law says can make a regular robbery an aggravated robbery. Now, robbery by itself is a second-degree felony, which means it is punishable by a minimum of 2 years up to 20 years in prison, up to a $10,000 fine. An aggravated robbery is a first-degree felony, punishable by a minimum of 5 up to life in prison and up to a $10,000 fine. So what I want to do for a couple of moments here is jump into some of the defenses, just a few of the defenses that might be helpful if you or a loved one is facing a robbery charge here in Texas. One of the first ones that I'm going to just tell you is, and this is simple stuff, and I wouldn't even necessarily call it a defense, but your attorney should be gathering evidence, going over it with you, looking to see if there were other witnesses that were present, other videos that might be available, or other surrounding evidence that would tend to show the police officer's representation of what happened or the alleged victim's representation of what happened is not accurate. So many times the police will not gather all the evidence that's truly there. They may not interview all the witnesses. They may interview the witnesses that are favorable towards their theory of the case, but maybe not so much to you. So it's important your attorney can provide and gather affidavits from other witnesses, or determine maybe there was video footage at nearby stores or restaurants or places where it might be able to show what happened is not exactly the way it's being claimed by the police, okay? Now, what about just good old-fashioned lack of evidence? Remember the state of Texas, so that's our first one, lack of evidence. The state of Texas must prove the case beyond a reasonable doubt. And sometimes all they may have is they may just have the word of an individual, and maybe some of the surrounding circumstantial evidence does not support the prosecution's claim. In that situation, your case may be able to be presented to a grand jury. So remember, every felony in the state of Texas must be indicted by a grand jury. And we've had many robbery cases where we take a look at it and we say, what is this? This is not robbery. And sometimes and I'll give you one example. Sometimes it's just theft. Oh, we've seen so many people go and commit a theft like shoplifting, all right? And then they come out and loss prevention chases them down and tackles them, Well, we had one case where that happened, where this kid, I mean, he was a kid, he was 19, but he was 19, never been in trouble, but he goes and he steals some video games. The loss prevention officer literally tackles him, throws him to the ground, but the loss prevention officer scuffs up his knee, he scuffs up his arm. And so what does he do? The police shows up and he says, look what this guy did to me. He attacked me. And so they charge our client with robbery, okay? My point is this, our client had no intent. There was no evidence to establish intent of literally trying to harm this person in the process of committing theft. We presented that case. You can present a case like that to the grand jury, and now the grand jury could lower that from literally a second-degree felony down to a Class B misdemeanor, which is now, literally a huge difference between a felony and a misdemeanor case in the ease of resolving that type of offense, okay? That's one example. So the next one is an alibi, just a good old-fashioned alibi. Maybe they're trying to claim, and we've had this happen before, well, someone will claim, 6 hours later or a day later, this guy tried to rob me. He tried to come and take my stuff. I think he took my iPhone and he threatened to hurt me. We've had those type of cases. But yet we end up getting evidence from either written witness statements that were with our client at the time, or maybe receipts, maybe pictures, proof of information that would show that individual was somewhere else at the time the alleged victim claims this stuff took place. An alibi could be your ticket to take care of the case in that situation. Then, what if you're the true owner of the property? Remember, you have to be taking the property of somebody else. You have to be taking the property of this other person. We've had instances where someone else came and took our client's property, and our client is just saying, you're stealing from me. Give me my stuff back. And they're trying to forcibly take the items back that were theirs. If there's no theft that's taking place, this is not a robbery. So sometimes if you are the true owner of the property that was involved in the question, you have a legal defense to have that robbery case thrown out, okay? Now, finally, we get into some of the lesser options like entrapment. This is rare, very rare that this comes up. If somehow someone was forced to commit robbery against their will, I almost hate to even mention that as an option under this, but we've only had 1 or 2 times where we've seen somebody where literally as part of an undercover drug operation, in order to not blow their cover, they're literally out committing this in order to gain access to someone as part of a drug operation. If that person ended up trying to be charged with robbery as a part of that process, that is absolutely would be entrapment if the officer was having them do something they would not do otherwise. That's kind of the standard, okay? Then finally, duress. Now, this defense is where if you've committed the crime allegedly of robbery, but you were doing it in order to prevent a greater harm. Okay, let's say you're doing it, and this is kind of also in more of a necessity defense, more so than even a duress. But let's say someone else is putting you under that duress, or you see someone else is being harmed, and you jump out there and you try to prevent something from happening that would be a greater harm to this. That might be an example of a necessity or a duress defense. Listen, that's very rare. I've only seen this happen a few times ever. But I want you to be aware of all the possible defenses you could be looking at. Finally, let me just tell you this. You cannot take a robbery conviction, especially if this is your first offense. You need to make sure you're working with a criminal defense attorney that understands the importance of not having a felony conviction on your record. Having a robbery conviction would affect the rest of your life. It could affect your ability to get a job. It can affect your ability to have a good name. It is seen as a crime not only of violence, but also a crime of moral turpitude because it involved theft. So having a theft conviction on your record will forever limit your potential in the future. So you need to make sure all your questions are answered and that you work with an attorney that can help you get past this and get this off your criminal record. If you are facing a robbery charge in Texas, or particularly in the North Texas area, and you would like a free case analysis or a free case evaluation, don't hesitate to contact the Fulgham Law Firm at 817-877-3030. Now, if you click on the link right below, I'm going to send you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Click the link. I'll shoot it right over to you. And if you've liked what you've seen here today, if this has been helpful to you, subscribe to our YouTube channel, and I'll look forward to sending you more content just like this in the near future. Thanks again for joining us.